Hello everyone, this is Heidi Meyers, immigration attorney. Today we're going to talk about the International Entrepreneur Rule, or International Entrepreneur Parole. The Biden administration has recently implemented the International Entrepreneur Rule. So if you think you might qualify, now is the time to apply. The International Entrepreneur Rule was initially finalized by the Obama administration in early 2017. However, the Trump administration was trying to get rid of it before it even went into effect. So the initial effective date was supposed to be July 2017, but the Trump administration issued a separate rule called the delay rule in an effort to first delay it and then to get rid of it completely. However, this was litigated in federal court in the District of Columbia, and the Trump administration was found to have violated the notice and comment provisions of the Administrative Procedure Act, and the court ordered that the administration allow the rule to take effect. However, since this was towards the end of 2017, and the rule didn't take effect until 2018, and then again the Trump administration issued a separate rule to try to rescind it. So the end result was that very, very few petitions were ever filed, and so basically the Trump administration was trying to squash it before it even got started. So the good news is that the Biden administration has now implemented the rule. So USCIS is now accepting applications under the International Entrepreneur Rule for parole. What are the requirements that you have to meet in order to qualify as an international entrepreneur? So first, you have to show that the business is a startup entity that was formed within the past 5 years prior to filing. So it has to be fairly recently formed within the past 5 years, and you have to show that it is currently doing business. Now, for the foreign national himself or herself, there are several requirements as well. So the foreign national applicant has to show that he or she is the owner of at least 10% of the business. And the foreign national also has to show that they have the knowledge, skills, and experience to be able to run the business. They have to have an active and substantial role in the business. So this provision is not for passive investors. It is for people who are actively running their business, contributing to the success of their business. So aside from the qualifications of the foreign national himself or herself, you also have to show that the business has received qualified investments from qualified investors. To be a qualified investor, the investor must be either a U.S. citizen or a permanent resident, or if it's a business that's the investor, you have to show that the business is majority owned by U.S. citizens or permanent residents. The startup must have already received at least $250,000 in capital investment, and this can be either from venture capital firms, angel investors, or startup accelerators. And as I said, these have to be U.S. majority owned, or if they're individuals, they have to be U.S. citizens or permanent residents. Okay. So, and then also to be a qualified investor, the investor must show a past history of success, that the investor in the last 5 years has made investments of at least $600,000 in one or more startups that have been successful in terms of job creation or rapid growth. All right. Now, so one option to show investment is the private capital investment of the $250,000. Another option is to show at least $100,000 in grants or awards from a federal, state, or local government agency. So this would have to be grants or awards from the U.S. government or a U.S. state or locality of at least $100,000. So that's the second option. The third option is that you partially meet either one or the other of the first two requirements, and you can show with other reliable, persuasive evidence that the startup is going to be very successful, that you're going to have rapid growth, that you're going to create jobs. So those are the three options. This is not a visa. Okay, so if you are granted international entrepreneur parole, you cannot later on change or extend, you cannot later on change status to a non-immigrant status such as E2, O1, alien of extraordinary ability, H1B, specialty occupation. You would have to first get an approved petition, depart the United States, get a visa, and come back. So this is a parole. This is not a visa, because this was created by the president's authority to issue a regulation based on sort of general wording in the statute on parole. So it is not a visa. So you do not need to get a visa from a consulate or U.S. embassy abroad. It is a parole. Okay, so the other thing is that you can initially get a period of 2.5 years or 30 months, and then it can be extended for another 2.5 years. So you may have the parole for a total of 5 years maximum. So as I said, prior to your parole expiring, you would have to apply for some other status, perhaps some other non-immigrant status, or perhaps in the meanwhile, you apply for your green card separately. All right, so once again, this is Heidi Meyers, immigration attorney, 11 Broadway, Suite 925, New York, New York, 10004, and my number is 212-791-4007 or 646-508-5225. And don't forget to like this video and subscribe to my channel. If you have any ideas for other topics for videos, please let me know in the comments below. All right, thank you very much, and we hope to see you again soon. Bye-bye.